would you like me to bring?
Thank you, Madam. Yes, please. I'm like 5 minutes, please. And good morning. May I please report, my name is Stacey Lerman, and I'm here today on behalf of the appellant, Lynn Zirkle. Thank you for the 5 minutes of rebuttal time. Your Honors, Lynn Zirkle bore the minimal burden which she carried of giving a reasonable explanation to overcome the rebuttable presumption that she exerted undue influence over Hugh Hope when he executed a new will in October of 2018. The trial court erred in finding otherwise, that there was undue influence, and there is a lack of competent substantial evidence to support that finding. Now, typically, I would
Given the findings about Mr. Barrett's testimony, that he was suspect, that Mr. Pope was suspect of Ms. Zirkle, and that the court found Mr. Barrett to be highly credible, how do we reverse in light of those facts?
two things, Your Honor. One, I'll start with the credibility question, but then I'll back into Mr. Barrett more specifically. First of all, this is really about sufficiency of the evidence, which I'll get into when I talk about Mr. Barrett specifically, because of course the trial court does make credibility determinations. And I know that this court does not reweigh evidence, but there is a lack of competent substantial evidence when a trial court misapprehends the evidence as a whole or misconceives the legal effect of the evidence. That is why there are cases that are reversed due to lack of competent substantial evidence. Now, turning to Mr. Barrett in particular, for example, Mr. Barrett last saw Mr. Pope about 5 or 6 months before Mr. Pope created a new will. That is exactly like the De Hotel case cited in the Darrow Venetian case, where there was a testator who died, and the only evidence of undue influence came from one employee, former employee of that decedent, who had last seen that decedent 5 months earlier, remarkably similar to exactly Mr. Barrett. Here, there is no evidence in this record from any witnesses other than Mr. Barrett to cast even a shadow, flicker of suspicion of the height of what you need to show undue influence when it comes to Ms. Zirkle. He's it. And that is not enough, as the De Hotel case shows. One witness who hasn't seen or spoken to the testator in 6 months is not good enough for undue influence. And in fact, Mr. Barrett, if we started poking at his testimony anyway, he has no notes, no records. He has pretty detailed notes, as you'd expect from a lawyer, including notes that Mr. Pope didn't want him doing any more legal work for him. But he has no notes if he was so concerned. There are no notes at all about this conversation that this occurred, that he had these concerns. These concerns were not relayed to anyone if they existed. And of course, Mr. Barrett was not a neutral witness. In fact, if this court affirms, Mr. Barrett is hired to probate the estate. Meanwhile, his testimony at times was inconsistent. It was inconsistent with a witness who was neutral, one of 3 absolutely neutral witnesses who had no connection to anyone in this case. Those 3 witnesses were Dr. McNeil, Marty Curtis, and Monica Bingham. Monica Bingham was a home health care aide who had to be tracked down for trial, doesn't have any connection to any of these folks. And her testimony conflicts with Mr. Barrett's. Now, again, I recognize your question, Judge Black, that the trial court makes credibility determinations. And perhaps the trial court will leave Mr. Barrett over his opinion. But at the end of the day, the trial court doesn't even give a nod, just backs away the evidence from these neutral witnesses. Doesn't even mention it in the trial court order. And again, going back to
I think you said Monica Bingham, and isn't this the same person that didn't see Mr. Pope after June of 2018? So I'm trying to figure out how that argument weighs against Mr. Barrett's testimony. You said he hadn't as well seen. Okay, so
I was going to say, I think that kind of goes hand in hand with that. That's the whole point. None of these people had seen Mr. Pope in this time frame. And what I think really to show competent, substantial evidence in a case like this, or true here, for Ms. Zirkle to rebut the presumption of undue influence, then she put forth a mountain of evidence that
which the trial court did not find her witnesses credible at the end of the day on key points.
I think, Your Honor, on not on key points. It is true that the trial court said there were some inconsistencies among various witnesses that I think are not points that ultimately have any bearing on the undue influence question. They were on the one hand, the trial court would say there's a crafted narrative, and then 2 pages later, the trial court would say these people are all over the place.
Can I shift your focus a little bit to the legal side of this? You mentioned the derivation case, and in your brief, you rely on several other cases in addition to that case, all of which arose under the statute before it was amended. And my question to you is, how is this case distinguishable from the Swiss versus Flanagan case?
You're gonna have to admit, I don't recall, maybe if you give me a few facts, I don't recall the Swiss versus Flanagan case particularly.
I'm not sure whose brief it was cited, and I pulled it in doing the research, but I will leave that there. It's a 2021 case from the 3rd DCA. If you haven't read the case, I'm not going to quiz you about it.
No, I mean, I think I did. I was going to say that I looked at a few cases just in preparation for this from 2020, 2021, and perhaps that's one, and I'm just not putting together the title with the date.
It's an undue influence case where the affirming the trial judges.
Wait, I think that the bottom line is, because you're right? There's the statute changed a lot of things, and so there's case law that courts are still relying on now, post statute from then, but we all know, for example, that the presumption is not vanishing anymore and those sorts of things. But I do think that the purposes, I mean, the facts that would go to whether there's competent substantial evidence to support undue influence does not change since these cases. Am I making sense, Your Honor? That hasn't changed anything. The statute.
I understand that basic continuation of that notion, and I think we could spend a lot of time talking about how the trial judge resolved credibility determinations, but I was focused on a little bit of the just doctrinal underpinnings of all that, and hence my question about Swiss and Flanagan.
Okay, I apologize, Your Honor. Then, I guess what I was going to say is, at the end of the day, no case would be reversible. With orders made, credibility determinations all the time. In the cases cited to this court, where there was a finding by a trial court of undue influence. In cases where the trial court is weighing family member versus family member, I mean, remember here, by the way, Hugh Pope has no family, his spouse has died, doesn't have anyone in the United States, doesn't have any kids. We're talking about charities that he's never spoken to, who are contesting his will. When the last time he did a will, he moved around the charities that he was leaving money to. And so at the end of the day, if a trial court could just size up evidence and every time say, I've sized up the credibility of the witnesses and I'm going to go in this direction, that's not ever reversible. Then we wouldn't ever have any probate cases with undue influence findings that were reversible. And we know that they are, because they exist. And that's why it comes back down to the competent substantial evidence standard, which under Florida law, if a trial court misapprehends the evidence as a whole, that is in itself a lack of competent substantial evidence. And that's what we are saying occurred here. For example, mid-circle, if you look at the cases, what do you have to do to overcome this rebuttable presumption? What are the kinds of factors that Florida courts think matters? One would be what I just mentioned, lack of family, for example. When you don't have a living spouse, when you don't have children, when you don't have relatives in Florida, let alone the United States, that might be something that ordinarily wouldn't matter, right? We don't care what a testator does or why he or she does it, but we're now in this position of rebutting a presumption that undue influence, courts are going to start paying attention to those things because they might have some bearing. And here, that's the kind of thing like in the Williamson case, which involved the conveyance of a life estate deed. And the appellate court, in reversing on undue influence, says it's not unusual to have a situation like this where you have a dead spouse, no children, and no relatives. It's not unusual for somebody to do something like this, and that's relevant in determining that there's no undue influence. Or, for example, Ms. Zirkle put forth lots of evidence.
Is that a rebuttable presumption case on the deed?
No, Your Honor. In fact, I was going to tell you that the cases I'll talk about.
You relied on Brad. One of them is Brad.
Yeah, and then Derivation, Langford, Williamson, Ramey, and here's what they some of them don't have a presumption. Some of them, the trial court said there was one, and the appellate court said, well, there wasn't. But even if there have been, it's been rebutted here. For example, the Ramey case.
Why don't you can you point in my direction a case where there's a rebuttable presumption case as far as undue influence in a will?
Take a peek. On the at least, on top of my head, no, most of the cases I'm talking about say, again, the rebuttal presumption exists in the statute and the trial court determined that it applied. Often people are fighting over whether the presumption applies. As noted in our briefs here, Ms. Zirkle really does not think the presumption applies, but recognizing that, you know, that's really a fact intensive.
I thought there was some concession that.
That's what I was gonna say, in the trial court, she didn't agree, but will concede on appeal that that is truly a fact-driven analysis that in the sense things would be.
Aren't we looking at then, I think the complaint here that your client, Ms. Zirkle, put forward evidence to rebut it? And I guess my question to you is, I think you pointed to Monica Bingham. What is that evidence?
Well, so that's what I was talking about. So in addition to the family status, she put forth evidence of Mr. Pope's personality, his state of mind, his stubbornness. I mean, that's pretty, the record is replete with references that Mr. Pope was essentially a bit of a cantankerous old man, that nobody bent to his will but him. Well, that's an important factor when you're talking about whether there is the rebutting of the presumption of undue influence. Again, in the Darabanesian case, the decedent was referred to as indomitable, fiercely independent, and unsusceptible to the influence of others. And in that instance, there is no undue influence. In the Lowry case, cited in that case, the decedent had a strong will, which was relevant to determining whether in fact there would be undue influence. Ms. Zirkle also put forth evidence that she was a trusted friend of Mr. Pope's. And that is really undisputed, I think. I mean, there's no evidence that she took advantage of him. She made sure that his wife got.
Let me ask you a question right there from
Yeah.
the whole issue of this life estate deed that was tendered within days of him passing away. Is that something we should consider when we?
Not at all, and I can, two reasons why. One, just because legally it doesn't matter. Two, to put to rest any concerns that there's something untoward about that. The former, everyone, both parties agree that the life estate deed has no bearing, and the reason it has no bearing is if Hugh Pope's will is, if his 2018 will was done correctly and is upheld, in favor of Ms. Zirkle, then it doesn't matter. The life estate deed is just effectuating what the will wanted. And likewise, Ms. Zirkle can see that if the will is no good, she's going to fight about the life estate deed conveyance. So, so there's no legal relevance, but also in terms of it happening, and why it happened, it doesn't look shady, for lack of a better term, that it occurred. All it was doing, again, is already what the will did. Ms. Zirkle didn't need a life estate deed to somehow do something. And second of all, actually, there's record evidence that what she was trying to do was actually Medicaid planning to try to get Mr. Pope. He, you know, ultimately he obviously died, but she didn't know he was going to die. And so she was trying to, she knew he was going to need a lot of care and needed coverage for that care. And she had gotten some advice that this would be a way to help him qualify for some Medicaid expenses. So there was just a reason for it anyway.
Is there some reason why she didn't consult an attorney rather than have her friend type up the will on her home computer?
Yes,
Those facts alone are alarming.
yes.
Mr. Barrett had already done 2 wills. He had done a codicil 6 months earlier. Would have been an easy enough thing. If all this was on the up and up, why not just call Mr. Barrett and say, hey, we've got a change for you. Let's take care of it. Wouldn't cost much. Would provide some insulation for Ms. Zirkle, but instead, just kind of bad optics that she's got her friend there typing on her home computer, being fed the information by her. So
Absolutely.
that's the
Right.
one thing I have a hard time with in this case.
Yeah, I think Ms. Zirkle would concede those are bad optics. But remember, Mr. Barrett's own notes say that Mr. Pope told Mr. Barrett he didn't want Mr. Barrett doing any more legal work for him. And so then when Mr. Pope decided to change his will, there's record evidence that came in, not through Ms. Zirkle, that Mr. Pope was at his, you know, if you'll recall, he used to go, he was independent before, you know, during this time he made the will. He rode the bus every day, he called folks every day. He went to, for social outings to the senior daycare center that he went to on his own. And it was while he was there one day, they had a social worker there who he met with, and the social worker said, he was talking about changing his will, and the social worker said, well, you don't need to do it. You don't need a lawyer to do that. And he kind of went, oh, okay. And he was known for being very cheap. I think we put an example in there, he was known for cooking Burger King coupons. And he was interested in changing his will and was told he didn't even know where to do it, and
What
so.
about the fact that there was evidence?
Or at your rebuttal time, if you want to keep, this might be a good breaking point, or unless you want to keep going, you want to ask a question.
And my only question was a follow-up to Barrett, who there's also
Go ahead,
evidence
give you the time.
Thank you.
that Barrett, that Mr. Pope had expressed concerns to Mr. Barrett about Ms. Circle, and you're in your rebuttal, I didn't mean to.
Okay, go ahead, you can respond.
Okay, and so I'm sorry for the question. So Mr. Barrett had,
Expressed concerns about Ms. Circle's intentions with respect to his property, and so that's a troubling fact.
yes, Your Honor, I think that's what I'm trying to address for Judge Black at the outset when I said, look, there's no doubt that Mr. Barrett is not what I'm gonna call a friendly witness for Ms. Zirkle. He's the only piece of evidence in the case from any witness that could at all go to undue influence, which I think is why you're asking the question, is that enough? And I was answering at the outset, no, it's not enough. First of all, he's not, the fact that he hasn't seen her in months is in and of itself a problem. You would raise the issue about Monica being up as well. And in any event, there's problems with his testimony, and at the end of the day, it's not competent substantial evidence for him in juxtaposed against this other evidence to reach that conclusion. It's just not, it doesn't, because the trial court's misapprehended evidence out of a whole.
We've cut into your rebuttal time,
Thank you.
so I'll preserve that for you.
Thank you.
Morning. Okay, please report. My name is Joseph Fleece here for the athletes. In preparing for today, I went back and just read the transcript of the court ruling at the end of the trial. And on page 938, the judge says, the primary thrust of the evidence and argument presented by Circle is to point to an alternative set of reasons for Pope to take the actions that he did. That's exactly what they're doing on appeal. They're disregarding the evidence and saying, well, the court should look at this other viewpoint. And that's not the law. The court can't reweigh the evidence. And I mean, what we're dealing here with the case of undue influence, presumption of undue influence. And when the statute 733-107 was changed in 2002 for that presumption, it no longer became a presumption that could be dealt with a reasonable explanation. The burden of proof actually shifted, and the proponent of the will then had to show a greater weight of the evidence that the will was not a product of undue influence. And this case is very similar to the case of the RBC Ministries versus Tompkins case. All the criteria present. And basically that it's out of the second DCA. So once the burden of proof shifts to the proponent of the will was established by the preponderance of the evidence, the non-existence of undue influence. And there are cases throughout the state of Florida that support that view. There's Hack versus James in the 5th DCA, the state of Vanderbilt, the 3rd DCA, Keller versus Keller from the 4th DCA, and even the estate of Murphy out of the 2nd DCA recognizes that further proof of coming forward with greater weight of the evidence. So there was no undue influence. And when Judge Lever asked about the West versus Flanagan case, and I think that is very applicable to this case. And that case said that although Swiss presented an explanation as to her actions, the trial court found her testimony unpersuasive. It's not within our province to decide which of the witnesses gave a more exact or truthful testimony. The weight to be given to the testimony of each of the witnesses, the credibility to the attached to is clearly within the sound discretion of the trial court. Accordingly, we decline the invitation to reweigh the evidence, reweigh the testimony, and if that includes the order below is well supported both by guiding principles and competent substantial evidence. I would submit to you that the trial court order in this case is well supported both by guiding principles of the law and competent substantial evidence. And I'm not going to get into the law where you can't really reweigh the evidence. If there's confidence in any evidence supporting the trial court's order, it must be affirmed. So unless you all have any questions, that's all I have to wait on.
Thank you, sir.
Your Honor, as was just, Your Honor, that you just mentioned, have to be well cited. For competent substantial evidence to exist, it has to be well supported evidence. It sounds like there's a debate about whether we're trying to reweigh evidence here and whether that it's all about credibility. And then, as I mentioned before, that's an argument that certainly applies in many instances, many appeals that come before this court, but not all of them. At the end of the day, the conclusions have to be undergirded by competent substantial evidence, and Alan Barrett's testimony isn't good enough for it. And I was looking through my cases, and Judge Smith, you had asked me about a case where there was involved presumption, and the draft case is what of the ones I could find. I either found cases like I told you that we mentioned before, where the trial court had found the presumption existed. They were still fighting on appeal about that, unlike us. But the appellate court went ahead and said, well, even if the presumption had applied, we rebutted it. So I think those are useful cases. But the draft case in particular, actually, the presumption was there, and then it was rebutted. The appellate court said no. The trial court said it wasn't rebutted, and the appellate court said yes, it was. The evidence there supported that. And in fact, the appellate court there talks about the factors and the evidence that would matter. And here we have lots of evidence, and I left my apologies. My notes, but what I was going to talk to you about was these are the kinds of factors that matter. This is the overwhelming evidence that the trial court misapprehended. The lack of any evidence of what the circle was trying to do, that she was overbearing, pushing, aggressive, those kinds of things. In the Ramey and Williamson cases, those kinds of factors matter. Reasons Mr. Pope gave folks that had nothing to do with the circle as to why he wanted to change his will. He had reasons that had nothing to do with the circle. That matches up with cases like Derivation, Ramey, and Langford, where there's no undue influence. When someone can show, like Ms. Zirkle, that the decedent had these other grounds for wanting to make changes to the will. At the end of the day, she was a trusted friend. This is no different than a family member. She was his companion. She was holding his hand when he died. She had a very close relationship with him. She threw him a 100th birthday party. When his wife died, it's plain from the record, his world was upended. And pretty much Lynn Zirkle was the one there for him, caring for him the way, if anyone has experience doing it, caring for the very elderly with all of their needs. She was filling those needs because she had become a good friend to the Popes over the preceding 2 years. And so in that vein, this is no different than all those other cases involving family members, nephews, you name it, where someone changes their will out of gratitude and includes those folks. That's not undue influence. And we are not asking for a reweighing of the evidence. We are saying here that Alan Barrett's testimony is not enough to constitute competent substantial evidence. There are no further questions. I ask that this court reverse and remand and implement in favor of Mrs. Zirkle on the petition to revoke the vote.
The next case is, I'm going to give it a shot. Otis Shalette is the versus McGonigal.